welcome to the in-depth series of Drishti IAS. Now, as the term of KK Venugopal as the continuing Attorney General of India comes to an end on 30th September, there is a challenge in front of the central government, as Mukul Rohatgi has said no to the post of Attorney General. So, what is the matter has not been specified. For no specified reasons, he has denied the position. That is not the case that we are going to discuss today. We are going to deal with many other facets of Attorney General of India from the perspective of your examination. We will know about KK Venugopal, what is the position of AG of India, appointment, term and removal functions, as well as is the AG covered under the right to information or not, can AG represent private parties, is the extension of the tenure of AG valid, okay? And in the last, we have a question as well. Moving ahead, let us talk about Kottayam Kattankote Venugopal. Okay, and it's very important that we know about him. He is a very distinguished personality. Born in 1931, he is a constitutional lawyer as well as a senior advocate. And he is the 15th Attorney General of India. Interestingly, the 14th Attorney General of India was Mukul Rohatgi, who was offered the post of Attorney General once again. Okay, and he has been in the service of the Indian government as the Attorney General since July 1st, 2017. He was designated as senior advocate by the Supreme Court in 1972 and served as an additional Solicitor General of India in the year 1979 to 1980. Also helped Bhutan and Nepal to draft their constitution. Apart from that, other interesting facts is that he got Padma Vibhushan in 2015, Padma Bhushan in 2002. He also earned the Grand Cross Award and a medal from the Bar Association of Bogota, Colombia. He also got a medal and citation from the Bar Association of Buenos Aires as well as Matanzas, Argentina. He was awarded the Global Award 2003 by Kerala Chief Minister and Iswara Iyer Distinguished Lawyer Award by Kerala Bar Federation. Apart from that, he has defended the government in many key cases such as Article 370, the case challenging Section 124A, that is the sedition case, and he successfully defended the government in the Rafale case in 2018. Apart from that, the constitutional challenge to Aadhaar, among other key cases. Mukul Rohatgi served as the 14th Attorney General of India from 2014 to 2017. Okay, moving ahead, let us talk about the current issue. Now, KK Venugopal has been aging. He is 91. He has requested the government back then that please, I need to rest now. I have an advancing age and we should carry on with another Attorney General. But the government said, no, please do continue for another term. He said, okay, but there was a restriction, the time restriction, because now it is going to be it has been almost 5 years. So more than 5 years. So now, as we see that this was a news from this year itself, June, July itself, that he is supposed to continue, but for a shorter period of time, and the time will come to an end on 30th September. The Attorney General of India is mentioned in the Constitution under Article 76, and he or she is a part of the Union Executive. Also, he or she is the highest law officer in the country and is assisted by Solicitor General and Additional Solicitor General of India. Moving ahead, if we talk about the history of Attorney General of India, MC Setalvad, that is Motilal Chimanlal Setalvad, was the first ever Attorney General of India, and he served the entire term of his service as an AG was 13 years long, from 1950 to 1963. He was also the chairman of the First Law Commission of India. Alright, now unlike the AG of England and Wales and the AG of USA, the Attorney General is not a member of the cabinet in India. Okay, remember that. This could be a tricky question. Moving ahead, let us talk about another facet, the appointment, term and removal. Let's talk about appointment first. The AG is appointed by the President on the advice of the government, and there is no such criteria set in the Constitution, but it's generally that he or she must be a person who is qualified to be qualified to become a judge of the Supreme Court. That means she must be a citizen of India, also must have been a judge in some high court for 5 years, sorry, not 7 years, an advocate of some high court for 10 years, and an eminent jurist in the opinion of the president. Term of office is not mentioned in the constitution, remember that. And the removal is done by the president. It's on the pleasure of the president. Okay, it's on the pleasure of the president, remember that as well. Moving ahead, let's talk about the functions. Now, according to what is there in the constitution, the first function is under Article 76 Clause 2, to give advice to the Government of India in cases which are referred to him wherever the Government of India needs to be defended or advised, to perform such other duties of legal character as and when required by him, to appear on behalf of the Government of India in all cases, to represent by the Government of India in reference made by the President under Article 143, in which the President can consult the Supreme Court, has to be advised by the Supreme Court on certain matters, to discharge the functions conferred on him or her by the Constitution or any other law. Apart from that, he or she has the right to speak and to take part in the proceedings of both the House of the Parliament, Lok Sabha and Rajya Sabha, and even in the joint sitting, and he can be made a member of the committees of the House of the Parliament as well. This is according to Article 88. And he or she does not have the right to vote. Remember that, does not have the right to vote. Privileges and immunities are the same, which is made available to the members of the Parliament, and his or her office does not fall in the category of government service, but they are not debarred from private legal practice, and they should not advise or hold a brief against the Government of India. These are the certain things that could be posed as a statement to confuse you, so remember them. Moving ahead, let's talk about a very important case. Is AG covered under the RTI or not? Now, in PN Duda versus VP Shiv Shankar and others, which was on 15th April 1988, the Supreme Court said that an Attorney General is a friend, philosopher and guide of the court. But in BP Singhal case, that was from 7th May 2010, it was said that by the Supreme Court that there is undoubtedly an element of lawyer-client relationship between the AG and the union government. That means secrecy should be maintained in whatever way they are communicating with each other. That is why AG is not a part of the RTI. The office of AG is exempt from the provisions of the right to information. Remember that. Moving ahead, now let's talk about, can they represent private parties or not? As I've already told, there is no barring of them that they should not present private parties. But Rule 8 of the Law Officer Conditions of Service Rules of 1987 bars the law officers from representing any party other than these: the central government or state government, or any university, government school or college, local authority or PSC, port trust, port commissioners, government aided or government managed hospitals, a government company as defined in section 617 of the Companies Act of 1956, any corporation owned or controlled by the state, and anybody or institution in which the government has a interest. So one thing that we need to understand over here, that apart from these, the AG cannot assist any private party, but it is according to the Rule 8 of the Law Officer Rules of 1987. And many cases have been there where exemptions can be made according to Rule number 10. We will talk about that as well. Now, it bars them from, this particular rule bars them from advising any party against the Government of India, bars them from defending an accused person in criminal prosecution, but exemptions could be done by the exemption if it is given by the central government. Accepting any appointment to any office or any company or corporation, or even advising the ministry without the reference of the law ministry. So remember these. Moving ahead, now let's talk about the Rule 10. Rule 10 of the Law Officer Rules of 1987, the same one, allows the central government to relax these provisions if there is a need to do so. But it was seen that many times the Solicitor General or the Additional Solicitor General, they were assisting private parties by getting exemptions by under rule number 10. Now here I am not talking about only AG, but other offices as well, like Additional Solicitor General and Solicitor General. Okay, and that was seen that it was too much, that private parties are getting assisted, and that was causing an impact on the work or the service they are going to give to the central government. So there were memorandums which were issued in 2011, 12 and 14, in which it was clearly stated that any officer can request, and it should be made for only for compelling reasons. Request should not be just random. It should be compelling reasons and exceptional circumstances. They can assist private parties, they can represent private parties. But again, because these two phrases were not defined, it created a lot of issue by many political parties. Moving ahead, now let's talk about the extension of the tenure of AGs. As we saw, MC Setalvad served for 13 years, KK Venugopal for 5 years. Many before that, many AGs also, took more than one term. They served for more than one term. So let us see the Law Officer Rules of 1987, in which it is said that a law officer shall hold the office for a term of 3 years. It's not in the Constitution, but here in the rules. Okay, and they can be reappointed for another term for a maximum of another 3 years. That means 3 plus 3, like this, like 6 years. Okay. Also, their appointment can be terminated by either side. That means in this case, either KK Venugopal or the Indian government can terminate the relationship. Okay. Moving ahead, let us talk about the question that I have given here. Answer it correctly. I will take your names in the next segment. Consider the following statements with respect to Attorney General of India. MC Setalvad was the first as well as the longest serving Attorney General of India, and the office of the AG of India is covered under the RTI. So we have to select the correct ones. Okay. So that's it. Thank you so much for watching. Stay updated.